Hello and welcome everyone for another Witty Wednesday session. So, today's topic is an interesting topic of succession planning, and I'm sure everyone has a lot of questions on it. So, we have today with us Mr. CA Raj Lakotia, sir. He holds an experience of over 20 years. He's a chartered accountant having an experience of more than 20 years, expertise in the field of taxation, including international taxation, auditing, transaction advisories, business in estate and succession planning. So, I don't, without any further ado, let's welcome Mr. Raj sir and have a wonderful session.
Thank you so much, Chetali, for the warm introduction, and I'm glad I've been invited for this session on the topic, which is a very less talked about, especially in Indian scenario. यदि हम Indian scenario की बात करें, I'm using Hindi and English both because I've just seen a message. किसी ने लिखा है कि हिंदी में बोलिए, तो I'll try to mix both the Hindi and English version of during my presentation. So when we talk about succession planning, this is a topic जो कि Indian scenario में, at least if we see, it is a topic which people shy to talk about, fear to talk about, or at times people think that if I talk about this subject in my family, then अभी से कुछ ना कुछ unpleasant scenario हो जाएंगे. कुछ thought process ये भी आते हैं कि why am I thinking about my death? Why am I talking about something which will happen after my death? But if I give you the numbers, I'll cover that during my slide, that such a big litigation it carries in India कि आपको ये देखना बहुत जरूरी है कि सक्सेशन प्लानिंग यदि आप नहीं करते हैं तो आप अपने बाद में अपनी फैमिली के लिए कितना बड़ा बर्डन छोड़ के जाते हैं. वी इंडिया में सक्सेशन प्लानिंग को लेकर के अवेयरनेस बहुत कम है. If I'm a chartered accountant, I consider that chartered accountancy course, especially in Indian scenario, finance domain में could be considered as the highest level course. But even in CA curriculum, I did not find a single, forget about subject, chapter on the succession planning. तो इससे रिलेटेड नॉलेज इम्पार्ट इंडिया में बहुत कम हुआ है, एंड इसलिए लोग जानते नहीं है कि इसके होने का क्या फायदा और ना होने से कितने नुकसान है. वी ऑल हैव बीन टॉट अबाउट हाउ टू अर्न मनी. We all have been taught about how to manage our money, how to invest our money, so that the money which we have earned and which we have saved for our future generation and for our future can become a good wealth. And I believe all of you are advisors to your client. Then आप सभी अपने क्लाइंट को एडवाइस भी करते हैं कि आपको यहाँ इन्वेस्ट करना चाहिए, रियल एस्टेट में इन्वेस्ट करना चाहिए, गोल्ड में करना चाहिए, सिल्वर में करना चाहिए, म्यूचुअल फंड में करना चाहिए. There are so many places where you want your client to invest money, but the objective for all is same, so that the client can make good wealth out of his savings and investments. But the last limb of this is, what will be the ultimate use of this wealth? How will this wealth going to help the family? When is it going to pass on to the family? And in what manner? Challenges आते हैं जब क्लैरिटी नहीं होती है, और क्लैरिटी नहीं होने से लड़ाई होती है. चैलेंजेस आते हैं जब जिसकी वेल्थ है उसने ये डिफाइन नहीं किया कि मैंने ये वेल्थ किसके लिए बनाई है, क्या क्या ऑब्जेक्टिव्स पूरे करने के लिए बनाई है. और व्हेन आप सबने सुना है, जिसका कोई नहीं उसका तो खुदा है यारो. बट देन यहाँ पे जिसका कोई नहीं उसका तो गवर्नमेंट है यारो, लॉ है यारो. लॉ do not differentiate based on the need. Law do not differentiate based on the requirement. Law do not differentiate based on the behavior or the relationship that you used to carry. Law straightforward कुछ लोगों को डिफाइन करता है कि आपकी वेल्थ उनको चली जाएगी, और इस सिचुएशन में सारी चैलेंजेस चालू होती है. With this premise, let me share my screen with you first and my presentation with you, and we'll try to understand the subject in a very layman language, in a very layman manner, so that my objective is कि आप सभी इस सब्जेक्ट को अच्छे से समझ सकें. And to achieve that, what I've done is I have tried to create a uh, storyline, so that with the help of the story, we will able to understand and correlate with our real life scenario, and get to understand कि इसमें आपके लिए क्या है, सक्सेशन प्लानिंग आपके लिए क्यों जरूरी है, या आपके किसी क्लाइंट के लिए क्यों जरूरी है. तो इन माय स्टोरी देयर इज दिस गाय कॉल्ड अंकुर, हु इज अ 55 year old, a self-made reputed businessman from Kolkata, having interest in IT and IT enabled services. तो अंकुर ने अपना बिजनेस खुद चालू किया. 25 साल की एज में ही स्टार्टेड विथ this new venture, and after 30 years of hard labor, giving his sweat and blood to the business, today the business has flourished like anything. The top line is good, the bottom line is good, he has good profitability, good market, good reputation in the market, good clientele, cash flows are also very good. However, uh, now he Ankur has a father who is now a retired person, and is also medically dependent on, he has some medical history as well, and is now dependent on अंकुर. अंकुर के पिताजी जो हैं वो मेडिकली थोड़े से अनवेल हैं, और उनकी रिक्वायरमेंट के लिए वो अंकुर के ऊपर डिपेंडेंट है. उनकी कुछ पास सेविंग्स वगैरह कुछ खास नहीं है. We have seen many people who are coming from the tier 2, tier 3 cities to the Mumbai or Chennai or Calcutta to start having their own business affairs, so that they can, earn good money and then settle the family. तो सिमिलर सिनेरियो में अंकुर भी कलकत्ता आए और अपना बिजनेस चालू किया, और पीछे पीछे उनके अपनी पूरी फैमिली को फिर कलकत्ता में शिफ्ट कर दिया. फादर वाज अ स्मॉल बिजनेसमैन इन मेदिनीपुर एरिया ऑफ व्हिच इज 4 hours ड्राइव फ्रॉम कलकत्ता. तो फादर ने अपना बिजनेस स्टार्ट करके ही हैज शिफ्टेड विद अंकुर. पास सेविंग्स कुछ खास है नहीं, और उनके मेडिकल नीड्स के लिए ही इज डिपेंडेंट. अंकुर की वाइफ दो शी इज अ वेल एजुकेटेड लेडी, but जैसा कि होता है, she choose to become a homemaker instead of joining uncle's business or looking after uncle's finances. He has one sister who is now widow. She doesn't have anyone to take care of, and Ankur being his brother, only brother, तो अंकुर की एक moral responsibility है, और अंकुर being a good guy, he wanted to fulfill his moral duty as well. तो अंकुर की सिस्टर की जिम्मेवारी भी अंकुर ने अपने ऊपर ले रखी, and she is totally dependent on him. डॉटर वन, अंकुर की पहली जो डॉटर है, शी हैज मैरिड अगेंस्ट हर फादर्स विश, लव मैरिज. अंकुर वाज नॉट हैप्पी विद द गाय. ही सेड कि नहीं, आप खुद से शादी नहीं कर सकते हो, बट डॉटर वाज एडमेंट, एंड अल्टीमेटली दे डिसाइडेड टू मैरी गोइंग अगेंस्ट द फादर्स विश. और तभी से फादर और डॉटर वन के रिलेशनशिप बहुत कॉर्डियल नहीं, उन दोनों में बातचीत नहीं है. फादर ने अपने सारे रिलेशनशिप उनसे तोड़ दिए. आपने हिंदी मूवी में देखा होगा कि यदि तुमने ऐसा किया तो मैं तुम्हें अपनी विरासत से निकाल दूंगा, समथिंग लाइक दैट. डॉटर टू अच्छी डॉटर है, फादर की सारी बात मानती है, तो फादर ने उसके लिए एक बहुत अच्छा संबंध देखा, एक अच्छे बिजनेसमैन के साथ शादी कराई. एंड जैसा कि हम जानते हैं कि शादी के बाद शी हैज बिकम डायरेक्टर इन हस्बैंड्स एंटिटी, और बिजनेस है, बिजनेस से बैंक से लोन लिया. बैंक से लोन लेने के कारण being a director, she has to give her personal guarantee. Today, after COVID, there were some challenges business were facing, and the bank loan has become bad. Or daughter two की personal guarantee may get invoked anytime by the bank, and if it gets invoked, then daughter two की जितने assets है that will be attached by the bank. And the last person in the family is Ankur's son, who who has done his higher studies abroad, is now settled also in abroad, running his own venture. He's not interested to return back to India, join father's business, and he's happy in his own with his own setup. आई एम श्योर कि ये सारे रिलेशनशिप, आई हैव यूज्ड मल्टीपल रिलेशनशिप, मल्टीपल सिचुएशंस इस पूरी स्टोरी लाइन में, एंड आई एम श्योर आप अपने नियर एंड डियर वंस फैमिलीज में, अपने फ्रेंड्स फैमिलीज में इस सिचुएशन का कुछ या मैक्सिमम पार्ट आपने अपनी लाइफ में देखा होगा. लेट्स मूव फॉरवर्ड. सो अंकुर गॉट इन्फेक्टेड लास्ट कोविड का जब फियास्को हुआ, then अंकुर गॉट इन्फेक्टेड by COVID, and after a long battle, he ultimately departed. And the hospital bills are running in lakhs, which are yet to be settled. Now, what is the after effect of the sudden death of Ankur? Some of these are listed here. पहली बात है, family shocked and settled. Obviously, the main breadwinner of the family is suddenly demised. तो family का shocked and settled होना तो बनता ही है. पर साथ ही साथ दिमाग में ये सारे क्वेश्चन चल रहे हैं कि हाउ वुड द फैमिली मैनेज देयर इमीडिएट नीड, हमारी रोजमर्रा की जो जरूरतें हैं, हु इज गोइंग टू, हाउ विल वी पे आवर रेंट, हाउ विल वी पे आवर इलेक्ट्रिसिटी, हाउ विल वी पे आवर डेली हाउस होल्ड एक्सपेंसेस, द traveling, the education expenses, insurance. There are so many expenses we incur on day-to-day basis. But since Ankur is not available, how we are going to make the payment of these expenses and who will make these expenses? तीसरी सबसे इंपॉर्टेंट बात है, हु इज गोइंग टू मैनेज द बिजनेस. अंकुर ने बिजनेस खड़ा किया, इतना अच्छा बिजनेस उसने बनाया, बट देयर इज नो वन फ्रॉम द फैमिली हु हैज एवर shown any interest in the business of Ankur. Nobody has any idea how to run this business. And in absence of Ankur's availability, the entire business is at stake today. India is considered as SME driven economy. 70% of the Indian, businesses are SMEs, and most of the SME businesses face the similar challenge because या तो सेकंड लाइन वाले इंटरेस्टेड नहीं है उस बिजनेस को ज्वाइन करने में, या सेकंड लाइन के जो लोग हैं वो किसी बड़ी सिटी में या किसी या अब्रॉड में सेटल्ड है, दे आर नॉट इंटरेस्टेड टू कम बैक एंड जॉइन द टू टेक केयर ऑफ फादर्स बिजनेस. अब एक बिजनेस को जिसको कि इन्होंने बहुत मेहनत से खड़ा किया है, बहुत मेहनत से बनाया है, जिसकी एक वैल्यूएशन है, जिसकी एक मार्केट में गुडविल है, वो सडनली खत्म हो जाती है बिकॉज इन्होंने अपने बिजनेस के कंटिन्यूटी के लिए या बिजनेस को कैपिटलाइज करने के लिए कोई भी स्टेप्स नहीं लिए. Who will take care of father and sister? As I said, father is dependent, sister is dependent on Ankur. But अंकुर के जाने के बाद में फादर का और सिस्टर का ख्याल क्यों रखेगा, कौन रखेगा? एंड why I have chosen father, why I have chosen sister, I will consider, I will uh, deal with that later during my slide. But for the time being, आपके दिमाग में ये ख्याल होने चाहिए कि फादर एंड सिस्टर के ख्याल को का ध्यान कौन रखेगा, ये एक बहुत बड़ा सवाल है. Who knows what are the assets and liabilities Ankur has and how to access that? Since किसी ने कभी फाइनेंशियल मैटर्स में इंटरेस्ट नहीं लिया, किसी ने बिजनेस की तरफ कभी नहीं देखा, nobody has any idea कि अंकुर के एसेट्स क्या है, लायबिलिटीज क्या है, नेटवर्थ क्या है, पैसे कहाँ रखे हुए हैं, कहाँ इन्वेस्ट किए हुए हैं. एंड सिंस ये किसी को पता नहीं है, तो हाउ टू एक्सेस दैट, बिकॉज मनी इज रिक्वायर्ड टुडे. How would one protect from misappropriating wealth accumulated for the benefit of the family? As I said, हम पैसा कमाना जानते हैं, पैसे को इन्वेस्ट करना जानते हैं. ऑब्जेक्टिव हर इन्वेस्टमेंट का यही रहता है कि हम वेल्थ जनरेट कर सके, वेल्थ क्रिएट कर सके फॉर द बेनिफिट ऑफ द फैमिली, फॉर द बेनिफिट ऑफ आवर फ्यूचर. But in absence of any idea, where is this money, parked at? Where is this money invested at? And how to access those money, there are chances that the outsiders may misappropriate the wealth, and that is where your entire objective, your entire interest of protecting your family will not be able to make. How to protect second daughter share from getting it attached by the court? अब अंकुर की डॉटर है तो अंकुर के वेल्थ में उसका हिस्सा बनता है बाय लॉ. आई एम श्योर एवरीवन नोज अबाउट इट. कल को उन्हें अंकुर के फाइनेंसेस से कुछ भी पैसा मिलता है और यदि इनकी पर्सनल गारंटी इन्वोक होती है, तो वो पैसे तो बैंक ले जाए. हाँ, अंकुर ने ये पैसा बनाया था, ये पैसा वेल्थ बनाई थी कि कल को फैमिली के किसी भी रिक्वायरमेंट को वो हेल्प कर सके इन at the time when the family needed this money. Instead of helping this money to the second daughter, the money is, getting enjoyed by the bank. Now, can it be protected? Yes, that can be protected. यदि आप timely steps लें, यदि आप timely solutions work out करें, then also you can protect your money to get attached by any outsiders. How to protect the distribution of wealth to first daughter. As I said, Ankur was not having cordial relationship with daughter one, and he was not interested to give any part of his wealth to daughter one. Right, wrong? I'm not discussing that, but this is his wish. It is his money, his wish, and since he was not interested to give any part of his, wealth to daughter one, in absence of any instrument that he should have entered into or in absence of koi planning ke bina daughter one would definitely inherit as per law, and that will go against the wish of uncle. These are some of the after effects. I'm sure if we discuss on this, there will be many such after effects. Forget about the psychological and other aspects which people have to deal with. इंडिया की बात करें तो पीआईबी की एक रिपोर्ट आई थी 2016 में which said कि there are 3 crore cases which are pending before various courts in India, and out of these 3 crore cases 76% cases belongs to property and family dispute. और इसीलिए मैं बोल रहा था कि इंडिया में अवेयरनेस नहीं होने के कारण लोग समझते नहीं है कि इसकी कितनी बड़ी रिक्वायरमेंट है, और लोग इससे रिलेटेड कुछ कुछ भी स्टेप्स नहीं लेते हैं. 76% इंडियन केसेस, इंडियन जुडिशियरी सिस्टम के पास जितने केसेस पेंडिंग है, 76% belongs to property and family dispute. Such a big magnitude of the problem that we are talking about. Now, वर्ल्ड की बात करें, इंडिया बीइंग a developing economy, we always follow the developed nations, and United States is one of our favored developed nation which we look up to. तो यूनाइटेड स्टेट्स की बात करें कि रिपोर्ट बताती है कि irrespective of their age, irrespective of age of the people, irrespective of income of the people, irrespective of education of the people, people are highly sensitive about their succession rights and also very proactive about their succession planning. And even the government also in US promote a lot. I remember COVID के पहले there was a news that एक कोई बहुत ही dangerous virus was activated in one particular jurisdiction, and the US government has issued this advisory that whoever is traveling to that area first make his will. So government is also very proactive and make awareness into uh, to the citizens to make their succession plan. However, if we talk about China, which is the world's most populous nation, second largest economy, one of the highest saving rates and mushrooming wealth, yet virtually no one has a will to pass on. And that's become a big problem in China as well. A lot of cases are traveling to the courts in China as well. With this premise, friends, let's try and understand what is a succession planning and what is succession planning is all about, and what are the instruments one can use to make plans successfully. Succession planning is a process through which you ensure transfer of wealth to the next generation in a hassle-free manner, and that too in the manner in which you want them to enjoy the wealth, or in a manner in which you want to distribute the wealth to them. So आपने जो पैसा कमाया है, जो आप अपने बाद किसी और को देना चाहते हैं, अपने फैमिली मेंबर्स को देना चाहते हैं या अपने किसी डिस्टेंट रिलेटिव को देना चाहते हैं, उसे किस प्रोपोर्शन में देना चाहते हैं, किस कंडीशन पे देना चाहते हैं, और क्यों देना चाहते हैं, ये सारी चीजें आप सक्सेशन प्लानिंग के थ्रू अचीव करते हैं. इस प्रोसेस को के लिए देयर आर मल्टीपल डॉक्यूमेंट्स और मल्टीपल इंस्ट्रूमेंट्स हम यूज करते हैं, जिसमें से कि दो सबसे वाइडली यूज्ड इंस्ट्रूमेंट है, वो है विल एंड ट्रस्ट. वी विल डिस्कस मोर अबाउट विल टुडे, a part of trust also we will discuss about it, because these are the two highly used tools for the personal successor. So what is a will? A will is a document which is considered as legal declaration of the intention of testator. Intention of testator is very important word. The will document reflects the intention of testator. Testator is the person जिसने अपनी will लिखी है. What intention it talks about, that how he wants to distribute or dispose of his possessions, his assets or his properties after his death. will एक सिंपल डॉक्यूमेंट है जो कि विल राइटर के इंटेंशन को दिखाता है कि वो अपने प्रॉपर्टीज को, अपने एसेट्स को, अपने वेल्थ को अपनी डेथ के बाद कैसे डिस्ट्रीब्यूट करना चाहता है. ठीक है. सो इंटेंशन इज वेरी इंपॉर्टेंट, एंड इसका कोई फिक्स फॉर्मेट नहीं है. यू कैन राइट विल इन एनी मैनर यू वांट टू. देयर इज नो फॉर्मेट व्हिच हैज बीन प्रिस्क्राइब्ड बाय लॉ. In fact, if I have to tell you, the smallest will till date was a 3-word will. It is just written in 3 words, which is all to son. मेरा जो कुछ है वो मेरे लड़के को जाए, all to son. But with the passes of time, so many cases which has traveled to the court, and there are so many judgments relating to this topic, this matters. एक छोटी सी लाइन आपके इंटेंशन को चेंज कर सकती है. एक छोटा सा वर्ड आपके पूरे विल डॉक्यूमेंट में इम्पैक्ट क्रिएट कर सकता है. सो व्हाट वी सजेस्ट इज, व्हेनेवर यू वांट टू राइट अ विल, टेक हेल्प फ्रॉम पीपल who understand the law, who understand the subject, and accordingly draft your will. There are so many things which we need to include in order to give will the effect in which you want it to be effective. So it can be a handwritten document also. It can be on a plain paper. There is no need of stamp paper. आप एक plain paper पे अपनी will बना सकते हैं. Not just your tangible, but intangible assets also you can bequeath through your will. Now we are living in a society which is a digital era, you can say. We promote a lot of digitalization. Our most of the documents, most of the details, most of the sensitive papers and things are probably available in online mode. Now, who is going to inherit, or who will have the right to access these accounts? Who will access your Gmail account? Who will access your Instagram account? Think of Amitabh Bachchan. Amitabh Bachchan ka Instagram handle has a lot of followers. Now that is his wealth, and if he endorses the product, he gets lots of money. Now, who is going to have the right to access his Instagram account after his death? Is also you can bequeath through your will. So not just tangible assets, intangible assets also you can bequeath through your will. If we talk about the characteristics, it's a legal declaration of the which reflects the testator intention, as I said, and it is with regard to his property. और हम अपनी फैमिली में अपने वाइफ के नाम पे, अपने बेटे के नाम पे, बेटी के नाम पे कुछ एसेट्स, प्रॉपर्टीज वगैरह बिल्ड कर लेते हैं, बट दोज doesn't belong to you. So you cannot make will for those properties. You can make will for assets or properties which are in your name on. And it manifests only after the death of the person. Till the time the person is alive, it is merely a paper document. But once the person is expired, then that will become a legal, valid document which reflects the intention of the deceased person. And that is why a will can be revoked or reviewed n number of times by the testator during his lifetime. Now, who all are the main parties to a will document? There are typically 4 parties to a will document. The first is testator or a testatrix. Now, the person who writes the will is called testator. In case of female, it is a testatrix. The second important person to a will document is a beneficiary. Beneficiary typically is a person who is going to get some benefits or is going to acquire some properties, assets, wealth, rights, title, interest from the will document. These people are called beneficiary. Now, beneficiary can be an individual or can be a non-individual as well. यहाँ पे will की importance आती है. I'm sure all of you must have read in the news about the Ratan Tata's will. He has given a part of his wealth for the maintenance of his dog. He has given part of his wealth to the society. He has given part of his wealth to his driver, his cook. Now, those people are the dog is a non-individual. Can law give any money to dog? The answer is no. But if you have anyone who is a near dear one, if you want to give anything to for the benefit of the people who are NGOs, who are society, if you want to do some philanthropic activities which are non-individuals, then it is impossible in absence of wealth. Similarly, if you want to give to a non-relatives, then also it is not possible in absence of will, because if the will is not there, the succession law defines certain relatives who will inherit the wealth of the person. Now there are people who wanted to support their any of his employee who has been very loyal throughout his lifetime, or any of his friend who has helped him during his bad times or something like that. Like in Ratan Tata's will also, he has given money to the driver or the cook. It is impossible if you do not have the will. So if you have will, you can give money to your non-relatives as well. Beneficiary can be a minor person or a person with special need. And सबसे अच्छी बात विल की क्या है कि आप बेनिफिशियरी तो बनाते ही हो, आप ये भी बोल सकते हो कि ये लोग हमारे मेरे एसेट्स से कुछ भी नहीं ले सकते हैं. You can define a non-beneficiary also, like in our case, in case of अंकुर ने यदि विल बनाई होती और अपनी डॉटर वन को, जो कि अदरवाइज बेनिफिशियरी है बाय वर्च्यू ऑफ लॉ, उसका इनहेरिट राइट है फादर की प्रॉपर्टी में, पर यदि अंकुर ने अपनी विल बनाई होती और विल में ये रीजन दिया होता कि मैंने डॉटर वन को मेरी संपत्ति का कुछ भी हिस्सा नहीं देना चाहता हूँ, और वो किस लिए नहीं देना चाहता हूँ, देन दैट वुड डेफिनेटली बी गिवन इफेक्ट टू. एंड दैट इज व्हाई the will carries so much of importance. Now, the next important party to a will document is called executor, is a person who is entrusted with the task of execution of the will. That is, after the death of the person, the executor has to produce the will to the court and ask for the probate order. Once the probate is granted, then he has to distribute the assets as per the provisions which are given in the will document. So, an executor can be a single person. You can have multiple executors, individual also, or a non-individual also can be an executor. Like nowadays, people want to appoint professionals as executor. तो आप किसी solicitor firm को, किसी law firm को, किसी CA firm को executor बनाते हैं, and that becomes a they do the execution job for a fee. And the last important party to every document is called witness. So, in order to have a legally valid will, you need to have at least two witnesses in place, and who must be an independent person. So, these are the four parties to a will document. What is a probate? After the death of the person, the will is produced to the court to see whether there is uh, uh, any mishappening has happened with the will document, or to establish the authenticity of the will document. Court follows their own procedure, and after that, they pronounce that the will is legally valid. And once the will is the probate is granted to the will, the executor can distribute the assets as per the wish of the deceased person. Now, probate is compulsory if the properties or assets are situated in Kolkata, Mumbai, and Chennai. But in areas outside these three jurisdictions, probate is not compulsory, it is optional. However, we suggest that you should get the probate order so that the will attend its finality. कभी किसी का फ्यूचर में कोई चैलेंज करने का चांसेस खत्म हो जाता है. Now, in what if will is not there, then you cannot obtain the probate. Then in that case, after the death of the person, the succession certificate has to be obtained from the local jurisdictional court, and uh, that state is called intestate succession, and it will list down all the details of the legal heirs and the properties of the person, and that will be distributed following the succession law of the land. So let's understand who can make the will. A person who has who is a major or who is of sound mind can attend the can make his will irrespective of whether he's a literate or not. He's an old person, terminally ill person, intoxicated persons are debarred from making the will because they do not understand what they are doing. And that is why it is very important that when you make a will, you should be sane and you should understand what you are doing with your assets and property. तो सवाल ये आया कि आप सबने एक मूवी देखी थी, गजनी मूवी। गजनी मूवी के आमिर खान को शॉर्ट टर्म मेमोरी लॉस की प्रॉब्लम थी। तो क्या गजनी मूवी के आमिर खान अपनी विल बना सकते हैं? तो लॉ हैज आल्सो कंसीडर्ड दैट कि अ पर्सन हु इज ऑर्डिनरीली इनसेन कैन आल्सो मेक हिज विल ड्यूरिंग द पीरियड ऑफ हिज सैनिटी। ये बात अलग है कि ये कैसे प्रूफ होगा कि जब उसने विल बनाई थी he was saying there's a way out for that as well. However, a person of that level can also make the will if he during the period of his sanity. Now, यदि will नहीं होती है तो ऐसी स्थिति को हम कहते हैं intestate succession, and in such scenario the succession law of land becomes applicable. And in India, the succession law is based on the religion that the person follows. If the person is a Hindu, a Jain, or a Sikh, Hindu Succession Act is applicable to him. In case of a Christian or a Parsi or a Jew, Indian Succession Act applicable to him. And in case of Muslims, Muslim law is applicable. So, what happens if a male Hindu dies without will? So, Section 8 of Hindu Succession Act has defined four classes of legal heirs: Class 1, Class 2, Class 3, and Class 4. सबसे पहले हम Class 1 legal heirs को लेते हैं, which has typically four relationships: मदर, विडो, सन एंड डॉटर। यदि किसी मेल हिंदू की डेथ होती है और ये चार रिलेशनशिप्स में कोई भी जिंदा है या चारों हैं या चार ये रिलेशनशिप्स कोई भी है, तो इस रिलेशनशिप में प्रॉपर्टी इक्वली डिस्ट्रीब्यूट हो जाती है। फॉर एग्जांपल, इन केस ऑफ हमको, मदर वाज नॉट देयर, ही हैड वाइफ, टू daughters and son. These are four people who are alive, which falls under class 4 legal heirs. So after the death of Ankur, Ankur's property will be distributed to these four people equally 25%. Now, father is not a class 1 legal heir. If there is no one in class 1, then we move to the class 2 legal heirs, जिसमें कि there are number of entries which are given. So we go sequentially, और हर entry में there are few relationships which are defined. तो सबसे पहली entry है father, सेकेंड entry है जिसमें कि siblings आते हैं। तो इस तरीके से हम एक एंट्री बाय एंट्री ट्रैवल करते हैं, और जिस एंट्री में कोई भी रिलेटिव जिंदा है, उस एंट्री में जितने रिलेटिव जिंदा है उनको प्रॉपर्टी इक्वली डिस्ट्रीब्यूट हो जाती है। नाउ इन केस ऑफ अंकुर, यदि बीवी बच्चे उसके नहीं होते, देन क्लास 1 में कोई नहीं था, तो वी वुड हैव मूव टू क्लास 2। क्लास 2 में फादर है, तो वी विल स्टॉप, फर्स्ट एंट्री इज फादर, विल स्टॉप एट फर्स्ट एंट्री इटसेल्फ, और फर्स्ट एंट्री में केवल फादर, कोई और रिलेशनशिप नहीं। तो entire assets of the Ankur would distribute to father. Now, if suppose Ankur के father भी नहीं है, then we move to the second entity which includes the siblings. Now, siblings में अंकुर की sister है, मे बी उसके और sisters हो सकती है, ये sister जो है widow है। तो इस entry में जितने भी relatives हैं, एक sister है, multiple sisters है, या सन डॉटर के बच्चे भी हैं, तो उनको अंकुर की प्रॉपर्टी इक्वली डिस्ट्रीब्यूट हो जाती है। Now, if suppose there is no one in class 2 also, then we move to class 3 and then we move to class 4 accordingly. And class 3, class 4 people are called ignates and co-ignates. Ignates are people who are related through blood, through male member in the family. अंकुर के father के भाई के बच्चे, they are related through blood, through male member in the family, becomes the ignates. And If there is no one in class 3, then we move to class 4, which are called coagnates, which are related through female member in the family. This is the order of distribution in case of male Hindu who dies without will. Just a quick example ले लेते हैं. Legal heir left his mother, father, wife, son, daughter-in-law, daughter, son-in-law. यहाँ wife, son, daughter, and mother would get 25% each being class 1 legal heir. Father, even though alive, won't get any share because he's a class 2 legal heir. And daughter-in-law and son-in-law would get share only if the son has already expired. यदि son expire हो गया तो उनकी जो वाइफ और बच्चे हैं, सन का शेयर उनके वाइफ और बच्चों को चला जाएगा. बट यदि सन अलाइव है तो सन को जाएगा. दिस इज हाउ इट इज डिस्ट्रीब्यूटेड. सिमिलरली इन केस ऑफ फीमेल हिंदू डाइज विदाउट विल, तो सबसे पहले हमें देखनी पड़ती है कि फीमेल हिंदू की प्रॉपर्टी क्या होती है. सो एनी प्रॉपर्टी विच शी हैज एक्वायर्ड बाय वे ऑफ इनहेरिटेंस, फादर से मिला, हस्बैंड से मिला, जिससे भी मिला, or she has acquired by way of partition. For example, father की HUF थी. I'm sure you are aware that daughter has become co-pastor in father's HUF. तो father की HUF से partition होकर के property उनके पास में आई. That becomes her absolute property. Or any properties which she acquired in lieu of maintenance, or by way of gift, or by way of own skill and purchase. Such property has become her absolute property, and in her case, order of succession is सबसे पहले इट इज डिस्ट्रीब्यूटेड टू सन, डॉटर एंड हस्बैंड. यदि हस्बैंड है, सन है, डॉटर है, या इनमें से कोई भी है, तो द प्रॉपर्टी गेट्स इक्वली डिस्ट्रीब्यूटेड टू ऑल ऑफ देम. बट इफ नन ऑफ देम आर देयर, देन इट गोज टू द लीगल हेयर ऑफ हस्बैंड. नाउ लीगल हेयर ऑफ हस्बैंड इज, जो हमने पास में देखा, अ मेल हिंदू डाइज विदाउट विल. अब आप सोचिए कि किसी फीमेल हिंदू की पेरेंट्स, फीमेल हिंदू के पेरेंट्स उस लेडी पे डिपेंडेंट है और लेडी उनका टेक केयर करता है, पर उन्होंने अपनी विल नहीं बनाई. तो लीगल हेयर ऑफ हस्बैंड की जो डेफिनेशन है वो इतनी बड़ी है कि कोई ना कोई रिलेटिव हस्बैंड का लीगल हेयर के रूप में जिंदा मिलेगा. और इस फीमेल की सारी प्रॉपर्टीज उस डिस्टेंट रिलेटिव को चली जाएगी इंस्टेड ऑफ हेल्पिंग हर पेरेंट्स हु आर इन नीड. सो दैट इज वेयर द इंपॉर्टेंस ऑफ विल इज कि लॉ यदि एप्लीकेबल होता है तो देयर आर मेनी people who are otherwise, in need of the support would be deprived. Now, if we assume that none of the legal heir of husband is alive, class 1, class 2, class 3, class 1 में कोई भी जिंदा नहीं, then we move to the next line, which is parents of the lady. If parents are not alive, then it goes to the legal heir of father, otherwise it goes to the legal heir of mother. This is the order of succession in case of a female Hindu who dies without will. However, there are two exceptions. यदि उस लेडी ने के पास कोई एसेट ऐसा है जो उसने अपने फादर से इनहेरिट किया है, एंड एट द टाइम ऑफ हर डेथ उसके कोई बच्चे नहीं है, तो केवल वो एसेट जो उन्होंने फादर से इनहेरिट किया है, फादर के लीगल हेयर को चला जाता है, रिटर्न हो जाता है. एंड सिमिलरली इफ उसने कोई एसेट हस्बैंड या फादर इन लॉ से इनहेरिट किया है, तो वो एसेट इसके हस्बैंड के लीगल हेयर्स को चला जाता है. दीज आर द ओनली एक्सेप्शन. Now, similarly, in case of, I'll skip this example because in interest of time, I'm sure you must have understand now. Similarly, in case of Christian, there is a order of succession that one third go if the leftover relatives are widow and lineal descendant, then one third goes to widow, two third to the lineal descendant. If leftover relatives are widows, there is no lineal descendant, only who are kindred. Then half goes to widow and half goes to the kindred. And if there is no lineal descendant in kindred, then everything goes to the widow. Similarly, in case of passes, if the leftover are widower and children, then all gets equal share. If there are only children available, then all gets equal share. So by and large, law gives the equal right to all the relatives, near and dear relatives. Basically, आपकी जो inner circle है, जो आपके spouse, बच्चे, mother, ये जो inner circle है, इन सब में ही distribution होता है. Similarly, in case of Muslim, there is a equation which one has to derive because son gets double of daughter, daughter gets half of son, spouse gets depending on बच्चे हैं कि नहीं है, and parents gets based on 1/6 share of the property. तो एक equation derive करके then we'll have to calculate who is going to inherit what. And if you have seen कि सब जगह distribution scenario is dependent on the percentage which one is going to acquire, not based on the need of the person who is going to acquire, not based on the support which the person is required, and that is where the entire disputes start happening between the family members. And the will helps you to avoid any dispute among the family member and distribute the assets as per the wish of the deceased person. It supports the near and dear one as per their need. In absence of will, they have seen कि बीवी बच्चे मदर इनको ही जाता है, बट यदि if you want to support your employee, if you want to support your distant relative, if you want to support someone, anyone who is beyond class one, then it is important. It helps you to fulfill your philanthropic goals as well. You have seen कि law में कहीं पे भी NGOs are not the relatives, NGOs are not the legal heirs, and everyone has some or other interest कि हम कुछ society को वापस return करें, and that is possible only if the will is in place. Possible issues are irreconcilable dispute in the family, testator wishes are not fulfilled, maintenance of family may be affected. जब आपके issues court में चले जाते हैं, तो it takes at least 10 to 15 years of time at least to settle the dispute. This is the average time to settle the dispute. And imagine the situation, आपका पैसा, आपका hard earned money, which you have uh, earned, and with the intention that it will help the family members as and when required, at the time when they need it most, that time the money is in the litigation, and the only person who is getting benefit out of that is the lawyers. And the process of transfer of assets become very lengthy and cumbersome in absence of will. So there are many myths also. On mill will need to be registered, will need to be on stamp paper. There is absolutely no need. You can have a will on a simple plain paper. The registration is also not compulsory. It is recommendatory. It is not mandatory. I have appointed nominee. Do I need will? ये बहुत सारे लोग ये question करते हैं. Let me tell you, nominee is nothing but a caretaker. It's a trusteeship, nothing more than that. The rightful ownership vest with the legal heir only. As and when the legal heir is established by the court, the nominee is duty bound to transfer the assets wealth to the legal heir. Similarly, in case of joint holders, if the property or the assets has come into the existence by combining or pooling of the resources, then both the joint holders has equal right in the property and they can bequeath their share to their legal heirs. However, if the joint holder is only for the namesake, then he is as good as a nominee, as good as a trustee, and he has to distribute the assets to all the legal heirs equally. It is too early to make the will. This many people have asked me कि यार हमारी तो एज ही क्या हुई है, 40 साल के हैं, तो हमें विल के बारे में सोचना. बट लेट मी टेल यू, in past 4 5 years at least we have seen the rise in young deaths in India, and there is no expiry date which is mentioned on our body. And at the same time, person between the age bracket of 35 to 50, when their parents are also dependent on him, their children are also minor and dependent on him, he should first think of making of their succession plan, because in both the end are dependent on him, both the end will have to suffer if anything happens to this person. So is the thought that it is too early to make will has no relevance. Please consider this. What if I change my mind? As I said, you can revisit your will n number of times. There is no bar as far as law is concerned. Why will I can gift? लोग बोलते हैं मैं गिफ्ट ही दे देता हूँ, क्या जाता है मेरे को will बनाने का. So there are many points which one should consider. As when you give a gift, you immediately hand over the assets to the person, and then literally you do not have any effective control on the assets. Gift also involve the stamp duty. Gifts are generally irrevocable in nature. Future में जाकर के if the person is not behaving in the manner in which you want him to behave, then in that case you will have to suffer. Similarly, the tax implications may also be there if the gift is given to an outsider. We have classical case of Singhania versus Singhania, where he has given his entire stakes to his son, and today he is suffering for his own maintenance. So it is not wise to give away everything during your lifetime. There should be a mix of gift and will for a proper succession plan. Cross-border inheritance are also possible. You can have under FEMA one can inherit the foreign assets properties, and similarly one can a foreigner can also inherit Indian assets and properties. uh, can I bequeath undisclosed assets to will? Yes, you can do that. There is no bar as far as law is concerned. However, you have to be smart enough to understand that in case authorities get to know about the assets which are undisclosed, then they have the power to recover the due tax thereon out of the assets. So he out of the estate of the deceased person. HUF assets, yes, one can bequeath his share in the HF property, which is not determined at this stage, which can be determined only at the time of HF partition. But once he, one's own share in the HUF assets can also be bequeathed through will. So these are some of the aspects relating to a will. I will just touch upon the trust also, which is also it's a very widely used and a great tool if for if you want to pass on the benefits to the generation, to the next generation, or to the beneficiaries, but at the same time do not want them to give the ownership of the assets. It is a great tool to be used for ring fencing, wherein the you can distant your assets from you, so that the liabilities that you have do not goes after the assets. So ring fencing के लिए बहुत सारे businesses इसको use करते हैं. You have good control on the assets during the lifetime and even after that, because जब आप trust बनाते हैं so you define the rules and regulations of the trust. How will the trust move? How will the trust work? What are the rights of the trustees, and who all are going to be the beneficiaries of the trust property? And बहुत तरह के checks you can put in place so that the beneficiary may be included, beneficiary may be excluded, trustees may be continued, and that is how even after the death of the person can control the assets and properties. It's a great tool to save state duty also, though in India state duty is not applicable, but NRIs who are in US, UK, where the state duty runs from 45 to 40 to 45%. Many use this tool to save the state duty levy. There are four types of trust, basically discretionary, non-discretionary, that is determined. Discretionary trust, when you give the discretion to the trustee to decide how much to give, when to give, and in what proportion to give. You can define the categories of the beneficiaries, you can define the beneficiaries, but or you can define the purposes for which you can give to the beneficiary, but you can put this discretion on the trustees to exercise his judgment and then give the money. Second type of trust is called determined trust, when everything is decided by you. You decide who are going to be the beneficiaries, who you decide how much they are going to get out of the trust fund, and other aspects relating to the distribution of the trust money. Revocable trust is trust wherein the settler who is put money into the trust keeps the right to revoke the money back, and the irrevocable trust is the trust wherein once you settle the money to the trust or the properties to the trust, you cannot ask that money come back to you. It once it is settled in the trust, it becomes it can be used only for the benefit of the beneficiary. And uh, uh, irrevocable trust is a great tool for ring fencing your assets from the outsiders liabilities. For example, यदि अंकुर ने ट्रस्ट बनाया होता डॉटर टू के लिए, और उस ट्रस्ट में डॉटर टू को बेनिफिशियरी बनाया होता टू एंजॉय द एसेट्स, टू एंजॉय द प्रॉपर्टीज, पर डॉटर टू को राइट नहीं दिया होता कि वो प्रॉपर्टीज उसके नाम पे चली जाए, so the daughter too would have been able to enjoy the benefits, and at the same time, the bank would not be able to attach that share. So it's a great tool to use as a ring fencing. Will बनाए या trust बनाए depends on multiple factors. Trust becomes effective immediately, or if you are making a testamentary trust, then it becomes effective after the death of the person. Will is effective only after the death of the person. Probate will में जरूरी होता है, dispute litigations के chances होते हैं, trust में नहीं होते हैं. विल के थ्रू कंट्रोल, जब तक आपका एसेट्स का डिस्ट्रीब्यूशन नहीं होता है, यू हैव द कंट्रोल, बट ट्रस्ट के थ्रू यू हैव कंट्रोल इवन आफ्टर द death of the person. During the lifetime, will is not possible to execute. How you can make the will, but will be enforced only after the death. Trust can be made today itself. One can make today itself. State duty saver will doesn't give you that benefit, but trust to trust you can save with the state duty tax also. And wealth planning for minor beneficiaries to will you can achieve this to a greater extent. But however, trust is the ideal tool for the minor beneficiary if you want to safeguard them. Few tips to avoid: keep your will at safe place. Share the place of storage with the executor or the family members, but do not share the content of the will. Sign will in presence of witness, which is very important. The first person to ask about the authenticity of the will is witness, so you should sign in presence of witness. Attach doctor certificate about physical and mental fitness, as we discussed about the Ghazni example. तो आपकी सैनिटी और आपकी फिजिकल फिटनेस का की ऑथेंटिसिटी डॉक्टर सर्टिफिकेट एस्टैब्लिश करती है। मेंशन दैट दिस इज योर लास्ट विल। आपने 3 4 5 यदि विल बना रखी है तो आप उन सारे विल की डेट्स दीजिए और उन सारे विल को revoke कीजिए, and then you make this a last will. And nowadays people have started video recording the will signing ceremony wherein they are signing the will document in presence of entire family members, and all are happy attending that. The testator is happy, the witness is also signing at the same time, and everything is video recorded, which creates an additional evidence for the court to understand that the will has been executed अपनी खुद की इच्छा से। If you want to write a will, this should be mentioned in your will: the date of writing will, your personal details, the details about your declaration that you have sound mind and good health. Also, that this is your last will and you revoke all your existing will if you have made any. The who is going to be the executor of the will, who is going to be the beneficiaries of the assets. Uh, Give details of the assets and the beneficiary against each and every assets. Give details of the contingent beneficiary. Now, contingent beneficiary is a person. If suppose we have appointed A as beneficiary, but at the time when the will is executed or the assets are distributing, A is not available or A is not interested to take the bequest, then who is going to inherit this assets or properties in absence of A? They are called contingent beneficiary, and that also you can define in your will. Non-beneficiary I have already dealt with. Special conditions you can give your that my last ritual should be performed in such manner out of my estate and something. Uh, and then the witness and testator signing the will document in presence of each other. So these are some of the aspects relating to the will and trust. I think we are running short of time. I will take questions as per your requirement, and let's get back to the audience. Chetan.
सो गाइज आपके जो भी क्वेश्चंस होंगे आप प्लीज चैट बॉक्स में टाइप कर लीजिए सो वी कैन आंसर. वी ऑलरेडी हैव वन क्वेश्चन फ्रॉम सचिन. says hello, please tell us practical steps to follow to have will of most of our clients.
I didn't get you. What is the question?
Practical steps to follow to have will of most of our clients.
So you need to engage some lawyer or some competent person who is expert in this subject, and then you can tie up with them. They can help you in getting the draft done, and you can deliver the will to them.
Okay. I guess there's another similar question like can we draft will and trust? So lawyer will be the correct person to guide us through that.
Yes. So will these are specific law based subject,
Hmm.
and certain things which should be taken care of. There are not certain. There are many things which should be taken care of while making the will or trust. Which, if you do not know, then there are chances that your what you want to give an effect to will not be effective. So it's better to take assistance from people who are expert in the subject.
So there's one more question from me. Uh, जैसे आपने स्टार्टिंग में कहा कि इट इज वेरी कंजर्वेटिव टॉपिक फॉर अस इंडियंस, वी डोंट गेट इनटू इट. सो एज अ पर्सन हु इज कम्युनिकेटिंग विद द क्लाइंट, हम उस टॉपिक को कैसे एक सिंप्लीफाइड वे में स्टार्ट कर सकते हैं, या फिर हाउ डू वी initiate the conversation where it is simple for us also and for the client also to understand this thing.
So I have shared with all of you what type of challenges one can face. You understand your client's intention.
Hmm.
आप कुछ क्लाइंट होंगे जिनका इंटेंशन है कि छोटे बच्चे को मेरे को हाई स्टडीज के लिए यूएस भेजना, जिसके लिए उसने फाइनेंशियल प्लानिंग कर रखी हो, बट सिंस उसने सक्सेशन प्लानिंग नहीं की, तो छोटे बच्चे को वो कॉर्पस जाएगा कि नहीं जाएगा, हाउ विल यू इंश्योर? You based on the reality of the client, the type of scenarios which I have discussed, you have to see what are the scenarios which are going to impact him or her in his life tomorrow if he is not available. And based on that, you can discuss with him or her that you have made this plan, you intend to do this, your objective is this, but how will you achieve that objective? The same thing you do with the investments as well.
Hmm. Okay, sir. We have one more question. What if the beneficiary denied before and there is no change made in the
I
will?
think it is not denied, it is died before.
Right.
Properly.
Okay,
So what happens is, as I said, you can define a contingent beneficiary. If the beneficiary is not available, then you can mention in your will that I want to give my this flat to X. Now, if suppose X is not available to take this request, then in absence of X, it should go to Y.
hmm.
That is one option. Second is if you have not done that, if you have just mentioned that my flat should go to X and X is no more, then in that case, the flat which is bequeathed to X will follow the succession law. That particular provision of the will be invalidated, and that flat will have the right. All the legal heirs will have equal right on that.
Okay. Uh, so there would be the same rules followed if it's a pagdi system property?
So in the Pagadi system, basically it is not your property.
Hmm.
You have the right to use the property. Now,
Okay.
in some places, this right expires after the death of the person, and you literally do not have any control. Then there is no assets, then there is no point of distribution. In certain areas, possibly that this right gets transferred to the legal heirs. Then,
Okay.
in that case, you can bequeath that right to anyone you wish to through your will.
Okay. So guys, do we have any more questions?
I believe all of us from Mumbai. Is it so?
No, it's pan India.
Pan India. Okay, very good. The question, if we have,
So what documents are required to transfer a housing society if nomination is done and no will is there?
so if nomination is done,
Hmm.
so housing society will transfer the assets to the
Hmm.
norm, the share to the norm. Okay, that is the role of the housing society. Housing society का obligation वहाँ पे खत्म हो जाता है. However, the question should ideally be that who has the legal right on that flat? The
Hmm.
legal right vests with the legal heirs equally in absence of will, even though the nominee is one person and the assets gets transferred to one person. But as per law, the all the legal heirs will have equal right on that assets. If you have will
Hmm.
and the will says that it should go to X, who eventually become the nominee as also, then only the legal right vests with the X.
Okay. Primanshu
I
here
hope
wants to know if there is any book for the subject.
you can search on the Amazon. There will be many books available. But see, it's a law-based topic. Unless you are into the law practice, you will not be able to give justice to the subject.
There's one more question. Can
Hmm.
we make quick income? To Y thereafter.
Can we bequeath income from property to X and the property to Y thereafter? So if I have understood your question well, you have a property, you want to give this property to Y, right? But you want to also impose a clause that whatever income which will come on this property from this property should go to X. The answer is no. Reason being, once you bequeath a property to Y and the property gets transferred to Y become the absolute owner of that property. Once he becomes the absolute owner of the property, then you do not have any control or any say how the property's income will be distributed by Y to anyone. What you should do is to create a trust, put the property in the trust, and give the income distribution right to the X and the property right to the Y. Then only it is possible.
Okay. So there's one more question. If a trust is formed there, then isn't taxation higher as inheritance become a part of income?
Inheritance becomes part of income. I did not understand your question. So far as tax is concerned, you have to understand one thing. If the trust is formed,
Hmm.
tax is one of the consideration for the inheritance or succession planning, not the only consideration. Uh, the first consideration is whether you have the effective control on the assets or not, or your objective are getting fulfilled or not. Till the time your objective is not fulfilled or your control is not effective, there is no point to execute any document for the reason that it will be tax effective. As it is, when you transfer any assets to the trust, there is no tax implication on that. At the same time, if it is for the immediate beneficiaries who are relatives as per section 56 to 10 of Income Tax Act, then there is no income tax on that. And so far as regular income tax on the trust is concerned, yes, uh, uh, discretionary trust carries the maximum marginal rate tax. However, one can plan it in a manner wherein you can deploy the trust corpus in the areas when you can deploy you can reduce the tax. You all understand how to invest into the mutual funds, which will carry 12.5% rate of tax in case of long-term capital gain. So you can plan that.
Okay. And what is the general cost in forming a family trust?
So in general, family trust formation cost you somewhere between 1 to 2 lakh rupees based on the criticality, and formation of drafting of a will cost you somewhere around 20,000 rupees, and at the same time registration for both the instrument registration would cost you somewhere around 15 to 20,000 rupees.
Okay. So we don't have any more questions. Thank you, sir, for explaining us in
Thank,
a very
thank you
simple
so much
manner.
for inviting me for this wonderful session.